Hi, welcome to the next video in our KSA PDPL NDMO self-assessment checklist. Today we're going to talk about disclosure of personal data. Obviously, your personal data doesn't just sit within your organization. There needs to be quite a lot of disclosure going on, and this question deals in the safeguards around that. So what is disclosure? So fundamentally, it's giving personal data to a third party. So you might be giving data to a supplier, someone who carries out a service for you. So if you're using Microsoft 365, for example, then you are giving data to Microsoft. It could be a partner organization, another company or another organization that you work with, that you might be disclosing data to them. Sometimes a government entity will ask you for data, and this could be anything from law enforcement to taxation to import-export. There are all sorts of regulatory bodies out there. You may well be giving personal data to them. And finally, obviously, people can make subject access requests, which may contain third-party data. There may be times in which you have to give data to individuals, and you should think about them as people to whom you are disclosing data. So there are lots and lots of ways in which to do this. So there are Article 15 provides lots and lots of safeguards that enable the disclosure. And of course, the first one is consent. Sometimes you can ask permission and disclose data that way. If the data is from a public source and you are not breaking any other laws by disclosing it, then that's absolutely legitimate. If the organization asking for the data is a government entity, then the government has quite a lot of leeway in and lots of purposes under which they can ask you for data, and you can disclose that way. If the sharing of the data protects public health or protects a specified individual, then that will enable you to share data, and of course your legitimate interest. So if it is in your interest and it does not unduly harm the third party, then absolutely, then that's fine. But when doing this, we cannot ever forget the principles. So whatever data you shared has to be minimized. The data has to align to the purpose for which you collected it, and it has to be proportionate. So you have to always keep in mind these basic principles whenever you're processing any data, and it's very important that all of your disclosures meet these principles. So there are some things that will stop the disclosure. So if the disclosure will threaten the state, the security, reputation, or the interest of KSA, if it threatens international relations, if disclosing the data will prevent crime detection or prevents justice, if it puts an individual at risk, if it harms the interests of a person who lacks capacity, violates any professional obligation. So for example, if you are a doctor and you have a professional obligation of confidentiality and that is then violated through this disclosure, then absolutely that can put a stop to it. And if it exposes a confidential source or harms public interest in any other way. So of course, the basic question is, well, we now kind of understand something about the rules, but how do we figure out how and when to apply those rules? The answer always comes back to build a data register. Build a data register which has your record of processing activities in it, and with it, understand what your disclosures are. Determine the lawful basis, and then do risk assessments to see what, if any, harm will happen and what will stop it. And once you've done that, you should be able to work out which disclosures are lawful and which are not. As always, get in touch with us if we can help you in any way with your PDPL program. Thank you.